Most people aren't planning for the day they need to secure the services of a criminal defense lawyer. So when the time comes, they often don't have the funds on hand. Fortunately, law firms across the country have found an innovative solution, accepting credit cards and offering payment plans via online payment technology like LawPay. LawPay allows you to easily and securely accept payments from anywhere, online, in your office, even at the courthouse. Plus, our scheduled payments feature enables you to offer payment plans to your clients. This way, your clients don't have to worry about paying one huge lump sum. Simply enter a client's payment details, the charge amount, and the transaction frequency. This minimizes their financial burden without risking non-payment. Once your payment is scheduled, your client is automatically charged and the payment is deposited into your firm's account within 2 business days. To learn more, visit lawpay.com/NACDL.
NACDL is the association of the nation's criminal defense bar.
I'm Mary Moriarty. I'm the Chief Public Defender in Minneapolis, Minnesota, which is actually called Hennepin County. So that would be Minneapolis and its suburbs. I've been a public defender in Minneapolis for 30 years. And the picture that you see on the screen here is actually of the intersection where George Floyd was killed. That's an intersection that's very familiar to me. I've had cases there. I drive through there. I've been there quite often since his murder. In fact, I took the picture that you can see here. One thing that struck me about his murder and the aftermath was people in our office saying to me, well, I see George Floyd frequently. And what they meant by that was they see their client, they represent clients where they see behavior like this on behalf of the police, but the knee was lifted before it was too late. And so one of the things that struck me about this is I actually agreed to do this presentation over a year ago, and who could have known what would happen in terms of George Floyd. And so the presentation I decided to give now is very different than the one I thought I would be giving. And I wanted to give this presentation in a way that kind of honored the memory of George Floyd. And so here is what I decided to do. I decided to make this presentation, what if George Floyd had lived? Because he would have been our client. If you're a public defender watching this, you've had many, many clients who were George Floyd over the years, who survived this encounter. And what you would see is that he would have been charged with obstruction of legal process. That's something that we have here in Minnesota. And I just picked some charges here. The first 3 we have in Minnesota. The last we don't. But I know in each and every one of your jurisdictions, you have something similar to this. And the idea is that the police are claiming that our client did something to resist arrest or something of that nature. And so I want to talk about what would we do? Let's say that George Floyd had lived and we were appointed or he hired us to represent him. What would we do if he was charged with obstruction? And as you probably know, he was being investigated for passing a counterfeit $20 bill. And let's assume for purposes of this presentation that he wasn't charged with that. So we are simply dealing with one of these charges. I thought long and hard actually about whether to show any video from the Floyd case. And I will tell you, I'm not going to show any video of his death. But we are actually fortunate here in Minneapolis to have body cam. And so we can see these interactions with our clients. And I thought it would be beneficial to many of you, either if you have body cam or you don't, actually see what this interaction looked like before it got to that tragic point. A couple of things about this video. I had thought about talking about representing clients in other cases that we have, because we have plenty of body cam video. But we actually have a standing order here in Minneapolis from our court that if we receive portable video, meaning body cam, as part of the discovery process, we cannot share that. We can't even show it to anybody. This particular video, as you may know, was leaked. And here's how this happened. So we have the standing order. However, sometimes the way around that, as you know, as defense lawyers, if you want something to be public, whether it's a memo, some piece of evidence, you attach it to a memo. And the lawyers for the police officers in this case did just that. They attached the body cam to a motion to the court, which theoretically made it public, but the court didn't allow that to be disseminated. And the media is currently challenging that. What they did was set up a room where anybody in the public could come and sit at a computer terminal and watch the video. And nobody was allowed to record it. They had to watch it, and they could take notes, but they couldn't record it. What apparently happened, and there's an investigation going on about this, is that someone actually recorded the video that they were watching on a computer terminal. So as you watch this video, understand that you are going to be seeing it as taped on a computer terminal. And so I'm going to show you parts of this video, not the whole thing, but I want you to think about how are you going to recreate this interaction or parts of this interaction for your jurors, whether you have body cam or not. And remember, as I start this out too, that the whole interaction here started because these police officers were called to investigate the passing of a counterfeit $20 bill.
I see your hands.
Damn, man.
Stay in the car. Let me see your other hand.
I'm sorry.
Let me see your other hand.
Please,
both hands. Put your hands up right now. Let me see your other hand. Put your hand up there. Put your hand up there. Hands on the wheel. Hands on the wheel.
I'm sorry, brother.
Who else is in the car?
Put
your foot back in.
I'm so sorry. God dang, man. Man, I got shot the same way as I was before.
Okay, well, when I say let me see your hands, you put your hands up.
I'm so sorry.
You got them?
Man, dang, man.
Put your hands on top of your head.
Last time I got shot like that, I was
Hands on top of your head. Hands on top of your head. Step out of the vehicle and step away from me, all right? Step out and face away. Step out and face away.
Please don't shoot me. Please, man.
I'm not going to shoot you. Step out and face away.
I'm going to get out of here, man. Please don't shoot me, man. Please, man. I just lost my mom, man.
Step out and face away. Step out and face away.
Please don't shoot me, Mr. Officer. Please. Don't shoot me, man.
Step out and face away.
You're not shooting me, man?
I'm not shooting you. Step out and face away.
Okay. Please, man. Please. I didn't know, man.
Get out of the car.
I didn't know, Mr. Officer. I didn't know. Stop resisting.
Right now.
Stop moving. Put your hand behind your back then. I'm not going to do nothing. Face in the door.
Get his other arm.
Hey, you come back. Stay in the car. Stop resisting, man. Yes, you are. Stand up.
Against the wall. Yes.
What I doing?
We're figuring out what's going on. Drop the bag.
Figure out what's going on.
Adam,
What's the problem?
Said something to him. It ain't us.
we was getting a ride,
I
sir.
just got my phone fixed.
You can ask
This my
Adam.
accident.
Adam know me.
That's my ex.
Are you good?
He keep telling me, get my car.
That's it, man.
Well, they
You
got
can ask
some
Mr.
Get
Adam.
ID?
Sir, you can ask Mr. Adam about me.
Do you have ID?
I'm on 38th Street.
Man.
320 or 44.
back to
Chicago.
Chicago.
About you, sir. I just came to buy the tablet, and when I bought the tablet, it didn't. He didn't
Oh
work.
my
Whatever.
God. He didn't even do nothing.
I got one of those. Hold up, sir.
You have ID?
No, I don't. My
You got
name's
anything with
Shawan
your name on
Renee
it?
Hill. Fuck, no.
Sir.
I just came over to get my phone to see I don't have a purse or nothing.
Mr. Adam
And my
knows
daughter
me,
is on her
man.
way to get me.
What's his deal?
I don't
Mr. Adam
know.
knows me, sir.
That's
His
my
business
ex.
is-
I don't know.
Why is he getting all squirrely and not showing
I
us
have
his
no
hands and just being all weird like that?
Because he's been shot before. He don't
Well, I
wanna-
get that, but still, when officers say get out of the car,
Got a
is
thing going
he drunk? Is he on something?
No, he got a thing going on. I'm telling you
What
about
does
the
that mean?
police. We have problemons all the time when they come, especially when that man took that gun like that. It's been one.
What's your first name?
He's pretty good. George Floyd.
What is it?
He's a good guy. George Floyd, she said. Oh, ouchie,
What
man.
are you on something right
I'm
now?
not knowing nothing.
You acting
Yeah.
erratic.
Man, it's
Let's go.
dead, man.
Let's go.
God, man. Yes. Yes, I was just moving earlier.
Let's go.
Man, what up? All right, let me come on down now. It's feeling better now.
Keep walking.
Okay, now, do me one favor, man.
No, when we get to the car, let's get to the car, man. Come on.
Dang, man. Oh, man. God, don't leave me, man. Please, man, leave me, man.
Here.
I
I want to watch that car too, so get him in.
Stand up. Stop falling down. Stay on your feet and face the car door.
You get a seat on him?
Please, get out the door, man. I just want to talk to you,
No.
man. Please, let me talk to you, please.
You ain't listening to nothing
I
we're
know.
saying, so we're not going to listen to nothing you're saying.
Can you watch that car? Just make sure no one goes in it.
I hear you, but you are going to face the door right now.
Listen up. Stop.
I'll do anything. I'll do anything y'all tell me to do, man. I'm not a listener, man. I'm not. You can ask him. He know me here,
Check
though.
that side.
God, man, I'm gonna do nothing like that, y'all. Why is it going on like this? Look at my wrist, Mr. Officer. I'm not that kind of guy.
The other side.
Mr. Officer, I'm not that kind of guy.
Stop.
Please. I'm not that kind of guy, Mr. Officer. Please.
Face away.
Please, man. Don't leave me by myself, man. Please. I'm just claustrophobic. That's it.
Well, you're still going in the car.
Anything sharp on you?
I won't do nothing to hurt y'all, Mr. Officer. No, sir. No, Mr. I don't have nothing. Why y'all doing me like that, Mr. Officer? Please crack it through me for me and stuff, man. I am claustrophobic for real, Mr. Officer.
You got him?
Could you please crack it for me, please?
Yes, I'll
Remember my
crack
name.
it.
Stay
I
with me,
will.
man.
I will.
Please stay with me, man. Thank you. God, man. I didn't know I was going to happen, man. Please, man. I just want my hands free. I don't want none of y'all, man. Nothing.
You got him?
Inside in your pocket real quick on your shirt. I'm listening.
And I understand that people do stuff.
All right, he's good. That's guns, whatever. There's nothing working.
Okay.
Grab a seat.
Okay.
having trouble walking?
I'll roll the windows down, okay?
Please, man. Please don't do
Take a seat.
I'm going in, Mr. Officer. I'm going to go in.
you're not.
I got to go in.
Take a seat.
Grab a seat, man.
Why y'all don't believe me, Mr. Officer?
Take a seat.
I'm not that kind of guy. I'm not that kind of guy, man.
Take a seat.
Y'all, I'm going to die here.
Take a
I'm going
seat.
to die, man.
You need to take a seat right now.
And I just had COVID, man. I don't want to go back to that.
That's still hard to watch. So what do you all know what the police report would say, right? It's going to say that he refused to follow commands, that he repeatedly pulled away from officers, that he kept putting his hands where the cop, couldn't see them. He physically refused to get into the squad car, and he seemed to be high on something. So you know those are the things that are going to be in the police report. And the question for us is, how will we and our client collaborate to tell his or her story? That's the crux of the question, right? Because if you have body cam, and this has been an interesting part since this body cam was released, I've followed some comments about it, and some people, and these could be your jurors, or at least potential jurors, have said, oh, we should have seen that video before. If he had just followed the officer's commands, none of this would have happened. And so we know we're going to have to explain what happened here. And the other thing is that if you don't have body cam, how are you going to bring that story, that narrative to life? Because as I said, I've been a public defender for 30 years, and clients can certainly describe something to me, but actually seeing it has a very different visceral reaction. And if we don't have body cam, we have to figure out how to bring that to life for our jurors. There's something I want to talk about that I think is really important, especially right now. This actually is right before a march that the lawyer staff in our office had. It was a day for any public defender's office in the country to gather together to have a national march in solidarity with our clients, and we had it. We're actually standing in front of the courthouse. It's actually right across the street. You can really see it behind me. It has plywood on it because there was a lot of damage being done during the uprising. But take a look at this picture for a second. And I think this picture of our office is pretty representative of a lot of public defenders' offices around the country. In that if you look, you don't see a whole lot of diversity there. We need to have more diversity. And in fact, when I look at that, I see two Black men, and they were both formerly incarcerated community members who came to march in solidarity with us. So it is critically important that we, as white public defenders, understand that we are representing most of the time on these types of charges clients who are Black and brown, and we simply don't have their experiences. This is probably familiar to many of you. This happened relatively recently. These are police officers in Aurora, Colorado, same police department that killed Elijah McClain. And here they were investigating a stolen car. And they stopped a mom and her children. And this picture, which many of you have seen, represents police officers pulling the children out of the car and putting them on the pavement and handcuffing them. The little girl there with the pink headdress on is 6 years old. Something like that is completely outside of my lived experience, and my guess, most of yours. That it would never happen to me, never happened to me as a child, would never happen to me. But that happens to Black and brown people routinely. And we have to recognize that. We have people who have been system involved in our office. Some of them may have those lived experiences, but many do not. And it's something we have to acknowledge and understand when we're trying to develop trusting relationships with our clients. This is George Floyd. In 2018, our clients were, I believe, 45.7% Black. And in Hennepin County, the population of Black people is 13%. So you can see we have very large racial disparities. So how are we, and I'm speaking to public defenders, but also private lawyers who are retained, going to develop trusting relationships with our clients? There's an added issue when you're a public defender. Many of you understand that we are viewed by our community as being part of the system, because we are in a sense. We don't like to acknowledge that, but in many respects we are. When you're hired privately, it's probably a little bit easier because you were chosen by the lawyer. They have paid for your services. But in any event, we all have to work really hard to develop trusting relationships with our clients. So how do we do that? We have to be authentic. I can't say ever to a client, I know what that must have been like, because I'm never going to know what that's like. I can be very authentic by saying, as a white woman, I will never know what that felt like. And I acknowledge that. But I want to try to help you, to work with you so that we can bring out what happened to you to your jurors. But effort to explain. Sometimes we just don't take the time, and we don't think of the things we need to explain because we live them every day, and we take them for granted. We just don't think about the fact that people who aren't in the system a lot really don't understand what a lot of the terms are, the acronyms, that kind of thing. And we need to explain to clients what they all mean. The other thing we can sometimes get into is trying to get the client to help us explain something that a prosecutor is going to ask. So for instance, if we said to our client, well, how come you didn't put your hands up when the cop told you to? that can come across as you, the lawyer, accusing your client of not complying, instead of saying, hey, here's what the prosecutor is going to say. The prosecutor is going to say, all you needed to do is put your hands up. And so we need to explain why that was something that you simply could not do. So let's walk through that. Help me understand that. Time. Particularly for public defenders, that is difficult. We don't have as much time as we would like. But time spent with the client and showing the client that we were working on the case is really how we develop trust. And so we need to invest time. The other thing is we just can't fly in there and say, hey, Mr. Floyd, tell me what happened here. Tell me what happened, and expect our client to tell us everything in one sitting. This is going to be small pieces sometimes, and we're going to have to invest the time to gain our client's trust. Acceptance that it's the client's choice. We may be in a situation with our client where our client is never willing to share how he felt, what he was thinking at the time. And that's his choice. And we have to accept that, and we have to figure that out early on enough to be able to talk to him or her about other potential options. But if we're being client-centered, we accept that that's our client's choice, whether we think we would do that or not, because we never know that we would. It's that client's life. Our job is to explain the different options and to work really hard to develop that relationship with the client, hoping that the client will go there with us. Okay, and that brings me to trauma. There are so many clients that we represent, most of them, if not all of them, have suffered some kind of trauma in their life. And especially after going through some experience like this or experiences in the past. And trauma is something that I don't think we educate ourselves on enough. And so I'm going to recommend this book that's fantastic, The Body Keeps the Score. And if we want to understand what trauma looks like, which does really help us when we're working with clients and we're trying to figure out what's going on here, but to really understand the impact of trauma and how we're seeing it in our practice. And that also means we just can't show up and say, client, tell me what happened here. It's not probably going to work that way. And we also have to acknowledge that we may be re-traumatizing the client by asking some of this stuff and then saying, oh, I got to run out of here, instead of checking in with them. How are you? That kind of thing. Many of us have access to social workers in our office, and sometimes it's a really good idea to bring a social worker, have the social worker talk to the client, because they can help with trauma issues. I highly recommend that book. So we can't just go into court and say, those cops were jerks. Why did they have a gun drawn? This was a counterfeit check. What was the big deal? That's not a theory of the case, right? That certainly plays a role here, but we have to come up with a theory. And when you look at the elements of your disorderly conduct, your assault, your obstruction, that kind of thing, you're probably going to find some intent or reasonableness or some place you can hook your theory, or that would be your theory, that your client was being reasonable given his own experiences, that your client did not intend to assault or obstruct. This was what was going on with him. And so we need to have a theory to explain that. Otherwise, you may find yourself shut down when you're trying to make certain arguments by the judge who's saying you're going for nullification. This really isn't a theory of the case. If you can hitch this narrative to a theory, you're much less likely to be shut down. So I mentioned this before, but this, of course, is what we hear and what I'm sure you hear from prosecutors all the time. Maybe it was a little too much that the cop showed up at the door with a gun drawn on this counterfeit bill. But, why didn't your client just do what the cop said? We wouldn't even be here. And that sounds familiar to you, I'm sure. And so we have to answer that. Not necessarily to the prosecutor, because if we're in trial or in some pretrial hearing and we're doing direct of our client, we're kind of past that stage. But this is a question that jurors are going to be asking, right? And the prosecutor is going to bring this up. A cops maybe shouldn't have done that, or, you know, a better prosecutor would say that, and try to acknowledge, yeah, not so great. But still, if he had just cooperated, nothing would have happened. So we need to be able to answer that question satisfactorily for our jurors. So one of the ways I find it helpful to be thinking about what kind of information how do I know that I have fully looked at all aspects of this case? And what I do is I tend to write down various scenes on a pad of paper. And so I just took some scenes from that video that you watched. So let's take a look at this. And one important thing is prosecutors tend to look at scenes as being only what was in the body cam, right? They tend to start from cop approach the car. We can think much more broadly than that. So here are some scenes. Cop approaches car with the gun. You can see the rest of those. But the other ones here are much broader. For instance, if you could hear what George Floyd was saying, there's some really interesting things that we need to follow up on, right? He says, I just lost my mom. We're going to want to know about that if that's something that he's willing to share with us. He says he was shot before. He says that a number of times. And that seems to be connected with his fear of the cops and perhaps is an explanation for why he was acting the way he was. He says when they're trying to put him in the cop car, I'm claustrophobic. So what has he been that all of his life? Was there a particular story that happened? What happens to him when he feels claustrophobic? There's all kinds of stuff to explore there. And I don't know, I don't think that came out in this video, but at some point on one of the body cams, he was positive for COVID-19. And at some point, he does talk about having just recovered and having some breathing issues. That's another scene. So I tried, and then I have passengers here because as you'll recall, there's a man and a woman who were there and told to get up against the wall. And the cop keeps saying, what's going on with this guy? And the woman says, he was shot before. And if you recall, the cop saying, well, yeah, I know, but so why is he behaving this way? There's a complete disconnect with this cop. But so who are those passengers? Are they witnesses? What do they have to say? So these are just some of the potential scenes that you can brainstorm and write down where you're trying to get at, like, I want more information on this. I need to talk to the client about this. So one of the exercises we do in training, and you're probably all familiar with this, is red light, green light. So let's say a lawyer is practicing an opening statement, and they get up and they say, Mr. Floyd was scared. And then blah, 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 blah. We might say as a coach, red light on scared, which means that the lawyer has to elaborate on what scared meant, like much more of a description of it. And then when you're satisfied that they have described that, you can say green light. You don't say red light or green light with a client, but it's a helpful technique to be thinking about when you're talking to the client. Clients tend to, just like we do, kind of skim over something that there's a whole bunch of stuff underneath. So when you might say, well, you mentioned that you were shot before. Can you tell me a little bit more about that? Yeah, I was. He might describe part of it and then go on to something else. He might not realize the significance of some of those events. You might know you might not know they exist unless you say, well, tell me more about that. How did this happen? You went to the hospital? What were the lingering effects on it? Have you ever had a gun pointed at you before? But just trying to draw out more information and particularly not assuming that we know or that you know what actually happened. So let's say we've developed that relationship with the client. We've brainstormed all of the scenes. We've talked to the client. We've talked to the witnesses. We know we've got a ton of information. What do we do with it to help prepare us for our direct examination? So I just picked this picture of a closet, which actually could have been my mother's closet, except she has a label maker and it would have had labels on the basket. So we need to organize. We can, and I'm going to talk about preparation even more later, but we have to prepare. And I think something that we tend to do as defense lawyers, as public defenders, is not prepare enough or as much as we do for other aspects of the case. Sometimes, I mean, we're not as used to calling witnesses. Sometimes we don't know whether we're going to call them. Sometimes we just don't invest the time we need with our client or any other witness to help them prepare to testify. But before we get there, how do we organize? What are we going to do? What is our direct going to look like? Are we just going to get up there and have a conversation with the client? No, we're not. We need organization. We need to have, sometimes people refer to them as chapters. They could, by the way, correspond to those scenes, like shot before. But what is a chapter? It is just a method to organize your direct or your cross. You can use it for either one. And the idea is, what point do you want to bring out in the direct that will, through this witness, that you need to make your closing argument, right? So what information, what point do you need to ask questions about to bring out information that will help you make your closing argument? And you want to collect the facts from this particular witness that will allow you to make that point. And then you go on to another chapter. And within that chapter, you are going to organize those probably broad to narrow. And that is going to be your chapter. Now, if you have multiple chapters, and you will, how do you organize them? What do you start with? And there's a concepts that I'm sure most of you know, primacy and recency. And these concepts come up in your opening, your closing, your cross, pretty much everything we do as trial lawyers. And this is just a cartoon depicting it. And the idea is, you're going to remember first what you hear and last what you hear. What I like about this cartoon is essentially he tuned out everything in the middle. And that's actually why you put potentially damaging information in the middle of your direct, like a prior conviction that you want to take the sting out, but you really want to hit on something that's really memorable that you want the jurors to take away at first or at the end, which is one of the reasons why we don't want to start out our direct examination the way most prosecutors do, which is, sir, could you state your full name for the record? What, if anything, do you do for a living? And often, by the way, their heads are buried in their notepads, and it's dull and boring, and we're not grabbing anybody's attention. So we want to start out with something that will grab attention. What are we going to do if we represent George Floyd? What chapter might we want to start out with? It could be any number of things. It could be, Mr. Floyd, I want to talk to you about when you were shot before. Mr. Floyd, you mentioned that you had lost your mother. Can we talk about that? Isn't that much more interesting than, would you please state your full name for the record? Do you have a job? That kind of thing. We want to grab people's attention. Now, if we're using chapters, and we're going to do chapters not in chronological order, we need to make sure that our jurors know where we're going. We don't want to confuse jurors. We don't want to confuse the client either. So we need to signal a change. We need to have some headlines, and we call them transitions or headlines. And they don't have to be witty. They can just be, let's talk about when you realized that that officer was outside your car. And so the client knows where you are, the jurors know where you are. You switch to something else. I want to take you to the moment when you realized that they wanted you to get inside the squad car. Or I want to ask you some questions about having previously been shot. So they're just headlines. They just tell everybody where we're at. And then you can start asking your questions. I mentioned how critical preparation is. And I know because I've been in this situation before, cross is our bread and butter, and we spend a lot of time preparing cross. And oftentimes direct gets short shrift. Sometimes we're not sure if the client's going to testify. There are any number of issues that are there, but to do an effective direct, you have to prepare. And it's only fair for the client to help them prepare as well. what you don't want to have happen, and I've had this happen a couple of times, is in the middle of the direct, it's Houston, we have a problem. And it was something that we could have anticipated, we could have helped the client avoid. So preparation will help us avoid those pitfalls. What does that look like? What are we preparing? So let's say there's some kind of impeachment material. If there's a prior conviction, there's something on which our client can be impeached. We need to talk to the client about that. The judge is allowing this prior conviction of some kind to come in. And so what we need to do is we need to talk about that so that we take the sting out of it. And so the jurors know we're honest and we're upfront about something. We're going to bury it in the middle, but we need to talk about that. What about use of real or demonstrative evidence? I remember once having a client testify. Actually, I don't remember the client. It was a woman testify, and I had a picture of her house. And I went up and I showed her, it was actually a big blow up of a picture of her house. And I said, what is this a picture of? And she was terrified and she froze and she said she didn't know. And it was actually a picture of her house. And I had made the mistake of not saying to her, hey, I am going to show you this picture of your house. And of course I had to do is this a picture of your house? Objection leading. What is this a picture of? So don't pop something on our client or your witness in the middle of direct. Any of you who've testified, I've testified before in court, and I can tell you, even though I've been a public defender in a courtroom for 30 years, testifying, totally different thing. Totally different thing. I feel in control when I'm the lawyer in the courtroom. I don't feel in control at all. Sometimes I feel like a deer in the headlights. And imagine what it feels like for a client when the stakes are so high. So go through everything with them carefully. What about objections? People don't know what objections are. They don't know what to do. So talk to the client about, hey, the prosecutor might claim he objects to something. Just stop, and I will handle it. Problem areas of testimony. There are always going to be some problem areas. And it's our job to anticipate those problem areas and to talk the client through. Like so for instance, it would be easy, I think, for a prosecutor or perhaps jurors to say, well, why don't you just get in the car? Why, and I don't know if you could see this very well, but when the cops were talking to that man and the woman, George Floyd had sat down next to the wall on the sidewalk. And so what was going on there? And you're trying to answer all of those questions. Another problem area maybe is I think I hear in there him saying, I didn't know. And part of me is like, I wonder, what was he referring to? Was he referring, like if you're a prosecutor, you're thinking he's probably referring to the counterfeit bill. I didn't know. Maybe it's something else. That could be problematic, but you need to listen to that. You need to listen to that tape over and over and over. Probably have somebody else listen to it too, so you catch everything that's in there. You're listening to it, and then you can talk to the client about it to explain what might appear to be problematic, but maybe it isn't. What about inconsistency? Just because of the frailty of human memory, the trauma, there are going to be inconsistencies. Let's say Mr. Floyd made a statement after the fact, and there was something different in that statement compared to what actually happened. Understandable, but we have to deal with it. One of the most puzzling things to me has been when I see a case and with a prosecutor, with a witness who's been inconsistent, and I rack my brain about what are they going to do about, how are they going to explain that the witness said this, and then they said this. And so often the prosecutor just doesn't deal with it, which is a gift to us as defense lawyers, because then not only do we get to deal with it and bring it up for the first time on cross, in our closing we could say, you would never have known anything about this inconsistency from the prosecutor. You wouldn't have known but for the fact that I brought it up. We don't want those tables turned on us, so we want to make sure we're bringing that up if there is an inconsistency and help the client explain that. opening the door. Sometimes there are rulings that you get when you make a motion in limine to keep something from coming in. And so often the client might say something that opens that door. Sometimes that can be character. You don't even have to make a motion in limine about that, but character can't come in generally. And then the client says, I'm a really good guy. I've never done anything like this. And then, that kind of opens the door. So it's our job to help the client understand those potential pitfalls so that they don't fall into any of this. We have to prepare the client for the cross. Because remember, we do the direct, we sit down, and then the prosecutor has an opportunity to talk to the client. It's really important to talk to the client about listening to the question. And if you don't understand it, you can ask them to repeat it. Don't do that every single time. But if you don't understand it, which is understandable, you might be nervous, you didn't quite hear it, you don't understand it, ask them to repeat it. But listen to the question. And then answer the question that's asked. And this is really tempting because anybody as a witness, I think, wants to get out their narrative of what happened, which isn't necessarily the question that's asked, and you could look like you're evasive. And so you want to explain to the client, look, I know there are things we want to get out, and if the prosecutor is trying to push you into answering a question, you want to explain. There's something called redirect, and explain what that is to them. I will have an opportunity to say, hey, Mr. Floyd, you started to answer this question when the prosecutor asked you X, and you didn't get to explain that. Can you tell your jury now what you wanted to say? So make sure you explain that. Don't look at me for help. As defense lawyers, we see prosecution witnesses look at the prosecutor. Like, we're asking them questions, and they look panicked, and they look over at the prosecutor, and we can make hay of that. We don't want our client in that same position. So we're going to be telling our client, you know what, do the best you can. Don't look to me. I can jump in and object, by the way. I feel that you're being treated unfairly, or I think you need help, which you will, but if you do, I'll jump in. But don't look at me as though you need my help. I think this is really critical. I actually think it's really critical for us as lawyers. Whenever I am cross-examining a witness and the witness is being more intense or maybe a jerk to me or something like that, I always try to lower my intensity, because then I'm going to seem like the more reasonable person of the two of us, right? And so I think this is true for clients too. They, everything is on the line for them. And they're up there in this completely foreign environment with all these people looking at them, and a prosecutor who's probably not being very nice to them. And it's tempting. Anybody would want to get into a fight with the prosecutor, be combative. But if you can talk to them about, hey, if you can bring it down, if you can take the high road, if you can just, answer the question and let the prosecutor look like he or she is being that you're winning. And part of this is talking to the client about the prosecutor's personality. What are they going to expect? I mean, from dealing with different prosecutors, they have different personalities. How they're probably going to behave on cross-examination. Then just make sure you're preparing the client for what that might be like. It's okay to be honest. What does that mean? Prosecutors like to say things like, well, you've talked to your lawyer in preparation for this testimony, right? And the client might be in is that okay? And it is, of course, right? Of course, you're going to prepare. And so you're going to be explaining to the client, yes, you're going to help them with that answer too. Yes, of course. And if a prosecutor says, well, your lawyer told you what to say, you can work with the client on a response. My lawyer told me to tell the truth. So, but just prepare them for that. A lot of people advocate for doing some kind of mock cross-examination so that the client can get a feel for what that actually looks like. And oftentimes people recommend that somebody else do it other than you, because depending on the kind of cross you expect them to experience in court, that may not be the kind of relationship or experience you want the client to have with you. But a mock cross can be extremely helpful. Prepare the client for some practical realities. And I think this comes under the like, we take stuff for granted, and we sometimes forget to talk to the client about it. And a big one here is what to wear. Now, if a client is in custody, it's, I think many public defenders' offices like ours have a client closet. So we have clothing that we can provide. But let's say your client is out of custody or they have their own clothes. It's really important to talk to the client about what you expect or what you would like them to wear. Because we know, unfortunately, presentation makes a huge difference to jurors. They're going to be making judgments based on what a client is wearing. And, strategically, you will have different ideas about that, but you want to talk to the client. What you don't want is to have the client show up in a T-shirt that says F the police or something like that. I mean, most of you probably had that experience where you represented a client on a drug case and they come in with a marijuana plant. So you just can't assume. You cannot assume, even if you say, I want you to wear clothes that you would wear to a job interview or church or something like that. I don't think we no longer have shared meanings. And so be really explicit about what you want. Is it a suit jacket? Is it a tie? What is it? But just help the client with that. What to expect? That's really critical. And it's, once again, one of these areas where we take for granted. We're in court all the time. We know how long it takes to get through security if a client is out of custody. I was in trial once and my client was out of custody and we took a recess and she went away and she didn't come back in time. And I was out pacing in the hallway and she came and the judge put the jurors in the box. And my client came around the corner carrying a Burger King bag. And I was trying to calm myself and say, okay, the jurors are in there. So we're just going to walk in like we planned this. And I opened the door and she had the Burger King bag and I had to say, wait, you can't take that in there. And she said, well, I'm hungry. Because she had no idea that she couldn't eat lunch at counsel table. And so it was just a reminder, okay, I have to be really explicit and make sure people understand what the expectations are. Attitude. I've never been in this position. I can only imagine how awful it is to have to appear in court on trial when you were the one that had the gun pointed to your head and yet you're the one who, the cop isn't on trial. And I think it would be really easy to be very frustrated and have an attitude. And that's just something you have to talk to the client about and say, hey, it would be understandable if this. And you're going to get to know the client's personality and how they're feeling about it and whether they're frustrated. And remember, we are the best people for them to vent their frustration on. Sometimes that feels very personal, but it isn't. It's not about us. It is really that we are the trusted person or the person that they can vent on. So have that conversation too. What about the courtroom? If you can, try doing that mock cross in the courtroom or a courtroom similar, obviously if the client's out of custody. Because it's a very different view from up there in the witness box and looking around and seeing that all these eyes are on you. So try to make that as realistic as an experience as you can. Okay, what about you? We've talked about having the client prepared. You have to be prepared as well. What does that look like? Where will you be? And by that, I mean, are you sitting at counsel table when you're doing this direct with your client? I would suggest not to do that because most of the time what happens is when you see prosecutors do them, their heads are down. They're not even having a conversation with the client. And you tend to do that when you're sitting at a table with your notes in front of you. But where are you going to be? Plan that. Know your jury room. Where can you be? So make sure that you're intentional about that. Know your material enough to move away from notes. I see this all the time. I see, defense lawyer prepare their direct, and they've got their notes, and this is what happened. Mr. Floyd, can you tell me what happened when? And their face immediately goes down, and they're looking at the notes, even though they don't need the notes. So I think the important thing is to get away from your notes far enough so that you can't do that kind of thing. But if you forget what the next chapter is, just go over and look and then reconnect with the witness. This is critical because this is supposed to be a conversation. You are supposed to be helping your client. This is a collaboration. And if you're just going to lob a question at them and bury your head in the notes, a couple of things. You're not going to hear things that they say. You're going to make it a lot harder for them because who are they supposed to speak at if they can only see the top of your head? And this goes into actively listening. And this is one of the hardest things for us. Most of us aren't particularly good at active listening. We mostly just hope people finish talking so we can make our next point. Actively listening and being present in the moment is critical. And it's hard because we're thinking, well, what's our next question? But when we're doing that, we're not present with the client. And it makes it a lot harder for the client to be present with us. So to the best of our ability, we have to practice being present in that moment and actively listening with the client. It is remarkable how often clients will say something, maybe under their breath, or have said something out loud, and I know the lawyer isn't looking because they certainly would have followed up on it, and they're thinking about something else. This is an organic kind of thing. Even no matter how many times you practice, it's never going to be the same. It's going to be in a courtroom. They're going to forget. You're going to do something. They're going to say something that you've never heard before, and you need to react to it. Maybe you need to draw out more. Maybe you have a gregarious client outside the courtroom, and then you get in and they freeze. You're going to have to draw that out. That's on us. It's not the client's job to be able to do that. That's why we're there. And we can only do it if we're actively listening. Be curious. Remember, you've heard this a number of times. The jurors haven't. And so asking those questions, and a client might say something that you hadn't heard before, and you don't want to bring out something that you don't really know what they're going to say, but you got to look like you're curious, like you're interested, no matter how many times you've heard this. And that's why I say here, use your body, your face, your voice. You're going to be able to help them. If you're smiling, you're acknowledging. People, you all know when somebody isn't listening to you and when they're not actively present. The client's going to know that too, and it is going to create more panic for them. So we are here to collaborate with the client when they're on the stand, to help them, to draw out information, to be supportive as we can. And we need to use our body and our face and our voice to do that. This is a quote that so many of us who teach trial practice use, because it really applies to practically everything that we do, right? And I think most people would say jurors don't really ultimately decide only on facts, but it's really emotions, it's story, it's how they felt. And so that's why this quote is so critical. People won't forget the way you make them feel. And I know this to be true. I did a murder trial back in 1997. I had actually tried this case, and this was my favorite client. Here he is, Damian Robinson, my favorite client in my practice. He was charged with a murder that I believe he did commit. The only way they could prove the murder was by also trying a robbery case as 404B evidence, because the same gun was used in both. And he unfortunately was convicted in the murder trial. And then the prosecutor wanted to try the robbery case and bring in the murder, and did bring in the murder as 404B evidence. So in the first trial, Damian did not testify, but he did testify in the second trial. And I think the pivotal moment in the trial really actually had nothing to do with factual guilt or not guilt. I asked Damian, because I when I was preparing him at the jail, we touched on this, and I saw that there was some emotion there, and so I kind of let it go until we were actually in trial. And so he's on the stand, and I say, so Mr. Robinson, what happened? Tell me about when you were arrested. And he went on to describe many, many police cars. He was in a taxi cab, and all these police cars show up, and people jump out with guns, and he has no idea what they're doing. But he's in his car with his puppy in the cab, in the back seat of the cab with his puppy. And he just starts describing what it actually feels like to have all these police pointing guns at him. And he was actually like physically squeezing, holding his puppy, and he had tears welling up in his eyes. And I'll never, this was in 1997, and I remember it vividly now. I remember how I felt. I had to kind of really work not to have tears welling up in my eyes. And I know the jurors did too. And they saw Damien as a human being, because the prosecution was trying to characterize him as a gang guy and all of this stuff, which he really was not. And he was acquitted of that. He was acquitted of that, even though the prior murder came in. So I think that's a really powerful example of understanding that how you make people feel, how you can help your client make people feel, can make all of the difference in the world. So a little bit, kind of the last thing I want to touch on is performance here. How do we help the client achieve their best success? Here are some techniques that really do help. And one of them is trying to bring the client into present tense. And so the way you could do this, if you were representing George Floyd, and you could say, I want to take you back. I want to put you in that position where the cop approached your car with his gun pointed at your head. And look at these questions. How are you feeling? It's not how did you feel? It's how are you feeling right now? What are you thinking right now? And the goal is to put your client in that position to be talking about, my heart was pounding, my mouth was dry, and just to put them in that present tense. It can be really powerful and compelling. Another thing we can do is talk about senses. Like, what are you smelling? What do you taste? What do you feel? What do you hear? Because that brings all of these other elements in that the jury can understand. So those are a couple of techniques that you can use to try to bring more life into it. So this is an aerial picture of 38th in Chicago, which is where George Floyd was murdered. And one of the things that struck me in looking at the body cam, actually, one of the things that's really hard to watch is when he's handcuffed behind the back and he's being walked across the street towards Cup Foods. And there's a mural on the wall, which, as I'm watching the video, I now realize, and I know, has his face is painted on it. But in the body cam, you can see him walking, and the mural is something else. One of the things that I have been thinking about a lot is, how do we make sure that George Floyd did not die in vain? What can we do? And I think these kinds of cases where we know our clients are subjected to this kind of behavior by police is one way that we can do that. We can do our very best to prepare our clients to develop a trusting relationship with them and really work to try to bring life to what happened in that interaction. And I think if we can help our clients do that, that is one way that we can honor George Floyd.